Okay, we are starting our Mingle Mastermind for this Friday. My name is Melissa Shea. I'm the CEO of Fashion Mingle, and today we're going to be talking about the weapons to protect our brand. This is part of our Fashion Business Survival Guide series, and so we really thank everybody for joining us today. I'm going to take a couple of minutes to get us connected on Facebook Live, and I would love for our panelists to introduce themselves. Shirin, you want to introduce yourself and tell everybody what you do?
Thanks, Melissa. Hi, everyone. So great to be here. My name is Shirin, and I am a fashion and branding lawyer and the founding attorney for Rakomova Law. So I basically help creative businesses in the fashion, beauty, lifestyle industry get set up for success. I've seen a lot of things happening. So I've been also working with businesses on coaching them internally to get the right systems in place, not just legally speaking, but also, financial systems, tax systems, insurance systems. And I look forward to helping inform our attendees on how they can help protect their business and grow their brand.
Wonderful. Well, thanks for joining us. Shirin is our expert today for the Fashion Business Survival Guide. Kat, how are you doing?
I'm pretty good, Melissa. Very grateful for all the press we got from New York Fashion Week. So we got Huffington Post, USA Today, Pop Sugar. So it was worth it. It was the toughest show that we did, but we got some great press, and we're just I'm going to go do location scouting for September. So that's one thing. And then I'm working on a love project, Love, Love, Love Live, Love, Love, Love Live, and Heels. And Mary Love is at the helm. So she's going to be participating in the mastermind in the attendees. So I'm anxious to have her meet all of us and to get into the Fashion Mingle scene. I love it.
Awesome. Thanks so much, Kat. And our lovely Dee just got back from the beach in Florida. How are you, Dee?
Yes, I'm good. I missed the beach, but I'm glad to be home. I'm just catching up, but I am the founder of DCG Media Group, and we are a PR, brand strategy, marketing, product development, and we do a lot of different events and pop-ups, and we're actually going to start doing it in West Palm Beach. So I'm excited.
Nice.
Yeah.
That's great. That's
stuff is happening.
Very nice very nice place to do business where it's funny.
Yeah, there's a lot of business over there.
Yeah, for sure. Well, let's get started today. Today we're going to be talking about the weapons to protect your brand. If you're just now starting a business, this is really important for you to be able to understand all the things that you need to have in place so that nothing goes wrong and you can protect yourself. But if you already have an established business, you might have had some bad things happen. and so we want Shirin to explain to us all the different legal things that we can do that should be just standard to protect your brand and how to avoid having problems in the future. So Shirin, can you give us a quick overview of the things that we're going to be talking about today? We're going to be talking about what's a trademark and why is that important? What's a copyright? How do you use those? When do you get patents? And when should you use NDAs and service agreements and things like that?
Thank you so much, Melissa. Yes, so let's get started. 5 things you'll learn today, hopefully once we get through all of this, is the benefits of registering your intellectual property, what an NDA is and why you need it, how service agreements will protect your business. We'll go into that more detail. And something I really want to talk about a little bit more, and it's a hot topic right now, it's differentiating between an independent contractor and an employee. And there's a lot of legislative changes happening. It happened in California, and New York is putting it on a bill. So I really want to get into that because it's really important for most brands that are, working right now in the gig economy. It's going to affect, your taxes, what you have to pay for and what you have to cover when you're working with others in the industry. So to first talk about your most important asset. And I say that with incredible emphasis. As a brand, your most incredible asset is your intellectual property. And what is that? That comprises your trademarks, your copyrights, your patents. Okay, what are these things? So think of a trademark as your brand identifier, right? Your brand name, your logo, and the slogan that you use to differentiate your brand's products from other sources. So in some cases, a trademark could also be a design patent, a pattern, or an element that's, not distinct and non-functional. So I want to focus on that because I've been having a lot of conversations lately with brands that have been established, and when we discuss the protections that they have for their business, what's missing is registration. And they say, well, I registered my business, that's my name, so isn't that protection? And it's absolutely not. So I want everyone to understand that registering your business with the state as an LLC or a C Corp or an S Corp or whatever, or a sole proprietor doing business as, right? So some people do a DBA. That's not the same thing as your trademark. The business name could be your trademark, but if you didn't actually register your trademark with the US Patent and Trademark Office and get a certificate of registration, then you don't have trademark protection under the statute. Because yes, you have protection under the law, but then you have to prove that. And, I'm sure one of our panel members here can explain a little bit more about what it takes to prove a trademark case. But without that, I just want people to know that that is a huge difference. Registering your business, even though that's the name of your brand, is different than registering your trademark. You have to have that registration. And the key reasons for that is, one, to establish yourself as the owner. So once you go through the registration process, you will get that certificate that by default, you're the registered owner, and anyone else who tries to take your name or contend that will have to, prove that. But two, the most important reason is, while you're going through that, if someone were to take your brand name and use it for their products or services, yes, you could send them a cease and desist letter telling them to stop doing that. And if obviously they've taken your brand, they've taken your customers, you have losses, you can tell them, you got to give me money for that. But if you didn't register your trademark, your brand name with the registration office, then one, you're going to have to pay out of pocket for all those attorney's fees to go after these people. And two, you're going to have to prove damages. You don't just get the benefit of statutory damages, which is, in the hundreds, and depending on how much damages are, could be in the millions. You don't get the benefit of that. You actually have to pay to prove that you suffered damages, even though that other company took your brand name. So all of this basically becomes a hindrance for any brand that's starting up or just starting to grow. Who's got that money in the pot to put towards this kind of legal expense? It's incredibly expensive, when all you had to do was, right at the beginning, put the investment. And it's not a great investment, but if you want a brand, you have to invest into it. Put that investment into protecting it at the very beginning, and do it right. Because if you don't do it the right way the first time, you're going to come up with problems in the registration process, which is going to cost more money. All of this said, I just want people to understand, one, there's a huge difference between registering your business name and registering your brand with the Trademarks Office, and the benefits of that. And I know Dee has a story, and I would love everyone to hear Dee's story, because it is incredibly important. And she is not the only one with this story, but Dee's story, you know, is really incredibly relevant.
And I want to say hi to Dell from True Model Management. Dell just popped on. Hi. I have a feeling Dale's got a few stories in this area as well.
So do you want me to share my story?
Please do.
Okay, I have a lot of them, but I'm just going to share one. I'm going to put my little legal hat on. So
okay, tell us the worst one.
Oh my God. Yeah. Plain lawyer does not work. You got to get a real lawyer who knows the law. Step one. Step two is do not take shortcuts. Shirin is so on point. I did it through a lot of these illegal websites like LegalZoom, where I said, oh, let me just, you know, it's cheaper, right? Because I looked at, compared to what, and it's not even that expensive, honestly, to do a trademark. But I thought, oh, let me do it on LegalZoom. And then LegalZoom, from my understanding, made it look like they registered a name that I had and that I had started, I think, in 2004. And it was really never registered. And although I had usage rights, meaning I had my social media, I had my website, I had the domains, right? I made money off this name. It wasn't officially trademarked by the USPTO.gov. And so, you know, long and behold, a little Chiquita Banana who was following me decided that she wanted to do a group named after this name. And you know, my interns were like, Dee, you know, there's somebody who's doing XYZ with this name. I can't divulge too much information because I won the case. And because I won the case, there's like certain things I had to sign that I wouldn't mention names or whatever. So I'm just giving you the brief update. To make a long story short, it was very expensive. And thank God I keep every single paper trail, every registration, every event that I did, the money that I made through all the years. And it took about 3 years. And, you know, at one point she got scared because in the law, when you trademark something and you click, I've never heard of this name, when you click, oh, I'm not aware, you know, you click that, you're creating, you're committing perjury. And so I got to prove that she was following me and that she went to one of my events because I had a paper trail. Wow. And so, you know, she got scared and you know, I had to fire 2 lawyers. I was on my 3rd one, who is amazing. And he got it done, but it was costly. Like, it was expensive, guys. And the lesson learned, and you know, it was a lesson learned. I needed to go through that because I realized you cannot take shortcuts when it comes to, you know, getting your legal paperwork done. You have to do it the right way. And so that led me to getting 2 other trademarks, which I did do the right way. But I'm just saying, it is worth getting a lawyer, having them fill out the paperwork, having them fill out the category. They will explain, you know, what's a registered versus a trademark, what's a copyright. Lawyers are lawyers for a reason, but get a good lawyer. And so, you know, because I had 2 other lawyers that really didn't do much and they were just billing me like crazy. So to Shirin's point, it's very important to protect yourself.
Yeah. Dale, I know you've had a lot of twists and turns with your business. Can you share any stories about trademarks?
Yeah, sure. And the first one, not exactly with the trademark, but with domain names, which you have to protect the brand that you're, you know, the exact name that you're going with, as long as it used with your brand, because management, if to be public business, it's just going to have a business.
Yeah, your
Okay?
internet's going in and out.
Oh no, I'm sorry.
Yeah, you maybe try reconnecting it.
But protect your name and simple.
Oh, I'm sorry. Goodness. Well, maybe disconnect and reconnect, and maybe you'll get a better connection. That happens.
I'll try and make.
Yeah. So, okay. So Shirin, so do we have any questions while we're still on the subject of trademarks? Does anybody want to ask questions about this specifically? Shirin, Jennifer's got a question. Is there a difference between the R and the TM, when you're registering something?
Very good question. Yes, there is absolutely a difference between them. So a TM is when you, when you have a brand name, you could put a TM next to it because you're saying to the world, this is my name, it's trademark. That doesn't mean anything legally. TM just means just short for trademark. But R is what you get when you register it. So that tells the world, that it's your trademark and you've registered, which means you've confirmed it. So now you're at the level of confirmation that it's your brand.
Quick thing, I'm on my thing. I was just speaking on my panels. Our internet sucks.
We've got. She doesn't know that she's live. Let me see if I can mute her.
We unplug it and plug it back in. Maybe it needs to do that.
Oh, I'm sorry. I'm like,
how do
I? But if I sit in the hall.
Okay, there we go. Okay, I've got her muted now. She's at her mom's house, I think.
Oh.
She's visiting. Her parents got her COVID vaccine, so she raced out for a visit. Okay, so with the trademark, then you can just on your own next to your logo or whatever add the TM. That's kind of like putting your stake in the ground. This is my trademark, but it has no legal bearing. You have to actually go through the trademark process and then you get the R. Yes. That's correct, Shirin?
Absolutely. You got it, Melissa. That's it.
Okay.
TM you got beforehand.
Okay.
And the trademark, the trademark process takes about 6 months, right?
Well, no, I mean, from start to finish, it's about 2 years. In the first 6 months, you go through the initial stage, right? There's phases. So the first stage you go through, and then they'll review your trademark application. Then there'll be an examiner's report that comes back. There's always something because it depends on the examiner that you have. Everyone's got a different way of identifying, and you have to be very specific. So you have to respond to that request, and you have 6 months to respond to it. And if you don't respond in time, your entire application is closed. So it's just dismissed.
Okay.
And if you do respond, depending on whether your responses were good enough, they may either, give you another, they may either push you through to the next stage, or they may give you more reports that you have to respond to. And again, each time you're going to have a deadline for these reports. And if it's not met, they just close your application. So you have to restart all over again, which means paying new filing fees, paying all these things all over again, if it's not done right. So there's a process that it goes through. And then from that, it goes into actual publication. So then it says, okay, we've confirmed that we don't have a problem with it, and we don't think there's other brands out there that are similar to yours, but we're going to put it out there for everyone to comment. So now it's published, and this allows other brands the opportunity to say, hey, wait a minute, this is very similar to mine, and I don't want you getting the registration. So there's a period of time where, other brands can come in and object to your filing. So there is that process too. And then if you don't get any, or if you go through that and you have to deal with that process now. So there's different phases of the application. So from start to finish, it's about 2 years of going through different phases of the application process. Yes.
Kat, do you have a trademark for Runway the Real Way? And HiTechMODA?
I'm in the process of doing it, you know, because I realized that everybody confuses it with the Real and Rent the Runway and all that. And I'm in the process of doing it because I think it's really important. And also, I think is there a distinction like between something that's an entity and something that is I mean, what I'm saying is because I've had it for 10 years, do I have some sort of a claim to it, like common law claim to it, because I've used it in the marketplace?
Absolutely,
Is
that's
that
a
a
great
possibility,
question.
Shirin?
Yes, absolutely. That's a great question. Yes, you do. I mean, yes, you do have common law rights to it. So let's say, for example, you go and apply for registration. The problem that you'll come up with is that if there was someone ahead of you in the application process for that name, now you're competing with them and they were first in line. So you have to prove to the committee that you are actually the one that should be first, and you're going to contend to their application because you're the real deal. But the problem is that if they went through the application process and they got their name registered, now you've got a problem. Because even though you've got common law rights, now they have statutory rights. They've got the federal rights behind them. So they're going to say, come and sue me for it because you had the opportunity to go through and object and you didn't. So that'll make it a lot harder.
Just owning the domain name is not enough, right?
Yeah, having the domain name's not enough. Yeah.
It's not.
And then Shirin, if you have the trademark for your company name, you are using it, you know, in commerce, and somebody else has your domain name, do you have any ability to get control of that domain name?
I mean, you can, if you've got it registered, I mean, if you have common law rights, not so much because you don't have a lot of bargaining power. But if you register it, then it gives you power to go and say, you are now using my name, even though it's in association with the domain, it's now your brand though. So, you know, and so you get the power by having the registration because now someone is using your name in association with, you know, their brand, and that's yours. And that's what you buy with registration, the exclusivity of it. So that's the distinction. So, I mean, it's not, you know, it's not absolute like anything, right? It still depends on, but it gives you that power over them in squatting.
How about categories? Because I had my first company was Emerging Visions Enterprises, and I didn't register it, and then an optical company came up with Emerging Visions, and I thought, well, it's just an optical company, you know, it's not fashion. But I changed the name because I was thinking, you know, it's glasses.
No, that's a very good point, Kat. That's another issue because even though it's in a different class and category of products and services, one, you're still going to come up with an issue because it's not distinctive enough and there could be confusion in the marketplace. Of course, you know, as a lawyer, we object to that. And I've had a lot of cases. For example, I had an apparel company that was, you know, in the midst of registration, and they were an underwear line, right? Undergarments and things like that. And through the process, we came up with issues with a tea company, you know, brands of teas that had a similar name, maybe, you know, typographically different, but similar name. And so they objected and said, hey, we've got this for teas. And we were like, but we're underwear. You know, no one's going to confuse teas and underwear. Nevertheless, we had to deal with that issue, and it can be an issue. And you may not get your registration because of that, because even though there may be different products and services, if it has the potential to create market confusion, that's the problem. That's what's going to prevent you from getting the name if someone else already has it. Yes.
Thanks. Yeah.
Let's bring in Dell. She moved her location in the house, so hopefully we've got better Wi-Fi.
Yes, I'm testing out a new location, so bear with me. I'm really sorry about that. But my experience is, and my advice to you is, if you have a brand name that you're going with, like my company is True Model Management. However, many people just say, oh, True Models, you know. when I started the company, I really didn't think of similar names that people will call us by a shortened version of the name, or, you know, something a little bit different. And I knew there was a website called truemodels.com. So it wasn't available. It was owned by a really cute Italian high-end car company. And I'm like, oh, that's innocuous. Okay, great. So if someone goes to truemodels.com, that's okay. We had True Model without the S, we had True Model Management. So we did do a few, but we didn't want to pay the extra right when we were starting to have truemodels.com. However, had I done that, that would have protected us from not being possibly confused with what is now a porno site. So the car company sold it to a porno site. So all the time now, I tell everyone we are True Model without an S. And we bought the truemodels.net, but we still don't own truemodels.com. And I'm always nervous that someone's going to click on the website because they're like, oh, those are their models? I'm like, we're so the opposite. You know?
Oh my God.
That's so frustrating.
Oh my God, I wish I was eyeglasses.
Crazy.
Man, that is tough. Well, okay, well, let's go on to the next topic. Let's talk about, let's quickly go over copyrights and patents. They're a little bit similar, right?
Right. Yes, absolutely. So copyrights and patents are also intellectual property. So a copyright is actually the original work of an artistic expression, such as a photo, a video, a blog post, or other types of website content. So this is where, again, where the brand's expression actually comes into life. So, you know, your painting, your blog posts, all of those, your social media content, all of that is copyright. It's protected under copyright law. And technically speaking, you know, you have the right, it is born upon creation, right? So again, you have common law rights to your work to say, hey, I'm the one who created this. But the difference between common law rights and registering those works with the Copyright Office is that you get that additional level of statutory rights. And that, again, is the same as, you know, with a trademark. You get the right of your attorney's fees. And with copyrights, you know, if someone took your work, took your pictures and posted it on their website and claimed it as theirs, yes, you can send a cease and desist letter, but, you know, a lot of times they're going to say, so sue me. Well, first you're going to have to register the copyright to be able to sue. So it's a requirement to even file a lawsuit. But more importantly, it's the money. It always comes down to the money. And when I speak to brands and I know that they're budgeting, you know, all these costs for their business, this needs to be the cost budgeted, because if you don't invest in it now and there's a problem, the costs to resolve it are exponentially greater. Mm-hmm. And I'm not trying to lighten this up, because it really is. And it's incredibly frustrating to not be able to help a brand recover what is rightfully theirs because they can't even afford that. So that's why registering your copyright is so inexpensive. It's so affordable. Just make that time and initial investment, you know, work with a lawyer that understands it at the beginning, and they can teach you how to do it for yourself. And then from there, you can load up your pictures, load up your content, and it's very quick and easy to get copyright registration. Within 6 months, you'll get the registration certificate. And now if anyone were to take your work, take your content, your blog post, and put it on their website or put it on their platforms, you not only send that cease and desist letter, you're registered. So you hit them with statutory damages, you know, so that in and of itself will scare anybody into not wanting to mess with you and take your things. So that's why it's so important to register. It's not just you have the right, of course you have the right, but you need to register to really enforce it, because otherwise most brands cannot afford the legal fees. You know, at that point, you're working on an hourly basis, not a contractual flat fee agreed upon basis. So that's one key that all brands need to do, is register their copyrights, because that, again, is part of your brand. And then the last thing I want to talk about, especially in the fashion industry, it's patents. So, you know, then that gives the owner or the inventor the exclusive right to make or sell its invention, right? And there's three different types of patents. So in the world of fashion, the relevant ones are utility patents and design patents. And a utility patent is used to protect like a machine, a process, or system. So for example, a new fabric that is water resistant, antimicrobial, virus resistant. I know Dee is working with a company that does, biofoam. And so that's an incredibly new process in fabric. So this would be under a utility patent. So they would get that protection. So nobody else can do that but them. And if somebody else wants to do that, they can now take that investment that they made into the patent and sell a license to other companies to then make their, make that fabric, make that process. And then on the other hand, you've got design patents that protects the ornamental design. So again, with design patents, it's a very fine line because it cannot cross into any part of the functionality of the design. So, if you've got a great cut, but, the sleeve is, collared in a certain way. Well, the fact is it's still part of the collar, and the collar has usage as part of the clothing. So you can't get a patent for that. But if it's purely ornamental, like just, the splashes of colors that are done in a certain way, right? Like think of it as a painting, like think of the Burberry stripes, the mark, that or jewelry, the Doc, and even, ornamental, you can talk about Doc Martens shoes, the structure, the way that the shoe is, the look of the shoe, the Hermes Kelly bag. These are all design patents because it doesn't go to the functionality of it. It's purely aesthetic. So if you have something that's purely aesthetic and it's original and you want to protect that from being copied, then you get a design patent for it. And again, these are all investments that you make into your brand, into your business, that's going to come back tenfold if you make the right investments. If not, you're just going to keep paying more money trying to protect what you already have. And that's where businesses can either succeed or fail.
I want to circle back to the copyrights real quick. We build websites and always put a copyright in the footer. Is that like useless?
Well, it's not useless because you're making a statement, again, just like the trademark. It's a statement that this is mine. I've created that. And by saying that, you have to be careful because if you didn't create it and you put the C on it, now you're obviously, that's not factually correct. So you're opening yourself up for an infringement action by someone who did create that work. So you have to be careful about that. But if it's your work and you put the C on it, yeah, absolutely. You're telling the world, this is reminding the world actually that it's a copyrighted content. So you cannot lift it without authorization.
But it's not officially registered copyright.
No, it's not
officially. So is there
yeah.
any way to do that to protect, like if you have, a blog and well, I mean, just as an example for all of this mastermind work that we're doing, we're writing a blog article that has all the tips that our experts give us. Someone could just like copy that and put it on their own website and start saying, hey, we've got all the tips for being a fashion business. Is there any way at all to kind of protect the content as a whole?
Yes,
on your website?
Absolutely. So what you would do is go to the Copyright Office online, copyright.gov. And so you could file it under collection. So you could file, register individual pieces like a painting, a video, a picture, or you could file it as a collection. So for you, it would be like the Mastermind collection, right? And then all that work and content that was created for that Mastermind collection would be filed all under one filing. You would just basically, and the great thing is now it's online. You don't have to do paper filing. So just, copy, upload it all into the system, pay the filing fee. I believe it's like $60 right now. So it's not that much.
That's great.
that much, as long as you know how to operate the system, of course. And there's questions that it's going to ask you about the authenticity and, you know, the authorship and ownership and these things. So you want to make sure you know how to answer those questions right. But then once it gets loaded up there, that's it. Within 6 months, if they don't have any problems with it, you get the certification that this work is protected. Now, anyone tries to copy and paste it onto their work, you just go, you know, cease and desist letter, you send them the registration number so they know you registered your work. So now they're really owing you a lot of money. And that's how you get people to stop doing what they're doing. Yeah.
Okay, cool. Okay, let's talk about NDAs. You know, I started out, you know, working with lots of company, you know, because I'm originally from Austin. So when I had a freelance business, I worked with lots of companies that were, you know, inventing new software, different things like that. And you always had to sign an NDA before you went into the first client meeting. With Fashion Mingle, you know, we kind of did that sometimes, but I've also read that, you know, NDAs are kind of like, people aren't really using NDAs anymore because it's kind of like seen as rude or something if you're going to talk to somebody about your business. So can you tell us, like, what do you feel as far as the trends are people, is this still something really important that you need to do, or is it just if you have something super secret?
That's a really great point, Melissa. Thank you for sharing, because that's one of the problems that I've been seeing with companies, is that they are not taking NDAs seriously. So let's start from the beginning. An NDA, a non-disclosure agreement, is an agreement between the parties that says everything that we're going to speak about is not to be disclosed. So if you're the disclosing party, then the recipient of that information cannot restate that information to anyone else or reuse that information for any other purposes. And it's more important than ever, I would have to say, Melissa, than the opposite of what the consensus seems to be, because especially now, people have a lot of ideas. Everyone's trying to be creative and create new concepts and work with others and collaborate. If you don't have that NDA, then you are basically opening yourself up to the opportunity to have that person go, you know, this is a great idea, but I really don't want to work with you on this. I would rather work with someone else that I would trust better than you, but I love the idea. So without the NDA, there's no way to confirm that the only way that this other person who now took your great idea and restarted a business with another partner is not authorized to do the work, is because you had an NDA signed by them where you confirm that you're the one that was, and it wouldn't be just the NDA. I wouldn't say just, live with the NDA. It has to be NDA. Then there has to be a confirmation emails. There needs to be a paper trail to the NDAs to show exactly the types of discussions that were had. And you keep that in a folder so that if anything should happen down the line, you've got proof that you are the concept creator, you are the inventor, you are the owner of that information that has now made someone else a lot of money. So no, it is absolutely important to have that, even with your friends and family, if not more important to have this with your friends and family. I'll just share a story of this brand that I worked with, and he was beside himself because his best friend and so-called business partner, that he was a designer, had a great idea for jeans, and was doing all the work and wanted help with this person on the business side of things. So disclosed all this stuff to him, didn't have him sign an NDA, and sort of the friend was sort of like, okay, I'll think about it and I'll get back to you. Well, a few months later, he found out that the friend ended up doing that business with another partner, and how they're outselling him in that business, and have put him out of business because they exactly did the same thing and were doing it at a lower price point. So of course the consumer is going to go to that business first. And now this person who had the idea is trying to get his business back, And I had to say, there literally is no way to prove who came up with the idea. So you're going to be spending a lot of money on legal fees, and you're probably not going to get the outcome that you want. So it was a really bad, conversation to have with a great creative person that just lost their business because they didn't protect themselves.
Like
Dale, you've got a question about NDAs?
I do. And Shirin, you gave great advice, and you started answering the question that I was just thinking, because I sign and provide a lot of NDAs, always coming up with ideas and collaborating with different companies. And most of them are very general and really doesn't say in the NDA like what topic you're talking about. And many times there are multiple topics. So I love the idea that you said like the emails to confirm. So in the actual NDA and then also in the emails, what is like the pertinent, really important information that needs to be included to like cover yourself better?
Great question, Dale. Yeah, so in an NDA, I try to be as specific as possible, but allow room for, for the parties to have a discussion about other things potentially and not be locked in. So that's why it's important to create a template for your business as opposed to just pulling out a template. So that template that's going to be created for your business is going to describe your business, what your business is, what your business does, and then of course you'll have a blank insert for the other person that you're going to be meeting with to also fill in at that opportune time what they are and what they're doing, so that it's clear who the parties, like where the parties are in the relationship. And then give an overbroad understanding of what the content is going to be, like what type of business conversation. Don't get into too much detail, because first of all, the person hasn't even signed it yet. So we don't want to just go, oh, here's the points that I'm going to talk about. And they're like, okay, well, I can do this by myself now. So you don't want to be too detailed, but you want to give a scope idea of what you're going to be conversating about, so that later on there's, again, there's a reference point of what you were going to talk about. So if it's, design ideas, processes, all these different things that in your business, you're going to have conversations with people about. But then, of course, once the person signs that NDA and you have the conversation, do a note, a note to file, and also confirmation email to that person. It was great meeting with you, speaking with you in regards to blah, blah, blah. And that's when you get detailed in the email after the meeting. And then that email gets saved to your file as well somewhere. And then, if nothing happens with that, so be it. You have it somewhere. Yeah. But if something were to happen, now you've got a place to go and pull out exactly the fact that the person signed an agreement not to say anything, and then two, what was actually said, what was the content of the conversation.
I have a question, Melissa, for Shirin.
Yes.
So when I work with a lot of different brands, and when we're talking about brand strategy, I do like 3, 6, 9 months, whatever. And when I do a proposal, one of the things that I had to learn, because before, years ago when I started, I would do a proposal, put all my ideas, and then I realized that this happened to me like twice or 3 times, that, a brand would say, oh, we're not ready, but then they would do the ideas, right? So I learned that when I do a proposal, there is a NDA clause in there, and all rights reserved. And then I put it also on my email that this is non-transferable. Like, I put that clause to protect. I don't give all my ideas, one thing with any brands and stuff, but when I do a proposal and I do deliver whatever it is, whatever strategy I'm offering, I do have a clause in each thing, because just to protect myself. Is there anything else you would advise for like a company like mine?
Absolutely. I mean, basically what you want to do is, so the NDA is that initial conversation, right? So when you do that intro consult with the brand and you're talking to them about all this stuff, you're obviously not getting too detailed in that conversation. But then when you do that, submit that proposal, essentially it's going to be part of your contract. So in that contract, you basically, if you didn't have them sign an NDA beforehand, the confidentiality clause of the contract, which is really what you're speaking to, is what's going to basically, resuscitate what was said in the NDA if you had one, or if you didn't, then you put all of that language in your contract, that none of this is to be, that once the parties terminate their agreement, that they cannot take any of this stuff with them, and so that you retain ownership of all of the strategies and processes. Another aspect of that is the ownership, the contract to hire portion of the contract. And this, we're kind of getting into service agreements, which we were going to talk about anyway. So that's another key term that you want to include. So confidentiality, of course, and a work to hire clause that shows who's going to own the intellectual property that is being created between the two of you, right? You're the brand strategist, and you may create processes for this business that you may want to take to your other businesses. So if you don't have a work to hire clause in there that says whatever you've created for this brand, aside from that, things that are very specific to the brand itself, that you retain ownership of all of those processes and things that you created. So that's another important clause to have in a service agreement that you're going to have to protect, again, what's yours and what's not going to stay with them. So basically, you provide services to them. Everything you've given to them stays with you. They cannot continue that after you. And also, whatever you've built, they can't redo on their own without your permission. So yeah.
This conversation we've gotten, it's taken us a lot longer to go through all of these different subjects than I expected. So I think I'd like to roll over to the next business mastermind, talking more about service agreements and the release of liability and waiver forms and the independent contractor and employee agreement. So let's plan, because I know that there's so much to talk about with us. So let's do that at the end of March, fourth Friday in March, because I know Dale also has some more questions about NDA that you want to bring up, correct?
I do, and just to hone in on what you just said, Shirin, work for hire clause, I think are really important, and I make sure we have them always in our updated employee handbook, as well as people that we sign NDAs and things like that with. My question relating to NDAs is, in most cases, I sign as like the executive of True when I sign them, and the ones that I get in return are usually by a high-level executive of the company. But then you show up for a meeting or a Zoom call, and there's like many people on the call, and most hopefully are like employees of the company. And I believe that when they're employees, you're covered. And also in our handbook, and we sign, is like employees have that NDA as well as like independent contractors. But what happens if like an employee, I give my ideas at a meeting, the president signed, and then their employee gives it, like, how does that work? I always wondered how you could protect yourself from all those extra people.
That's an absolutely great question. And actually, you go back to the NDA itself, because if it was drafted right, then it includes that language in the provision that this NDA applies to if you're signing it with a company, so it's business to business, then as representatives, of course, of the company, you're representing that everyone in the company, whether an employee, and actually, again, if the language is done right, or an agent or a contractor of that company is also obligated under that, under the agreement, under the NDA. But you go the additional step and say, and that you ensure that they are signing documentation to confirm that they are understanding that they have a confidentiality requirement for their connection. So, you take the ownership, the responsibility off of you, and now it's on them. So now it's on the company to make sure that the employees know that they are under a confidentiality clause. And if they're working with subcontractors like agents and all of this, that they also have that agreement under their agreements, their contractor agreements. Because if something were to happen, let's just say something were to happen with an employee, now you found out that, this company's employee just took the work that you just, the confidential information is now doing it. So you're knock, knock, what's going on? This was something that was conversated with, with this company, and you've received this information without authorization. And if they were to say, well, they're not responsible for it, you don't need to worry about them. You sue the company, and you can sue them as well. But basically, everyone is responsible to you if there was a leak of confidential information. So the person that's signing it had to acknowledge that everyone else that they're working with is also under the same clause. And if they're not, you basically sue the company that has the biggest money. I mean, that's really the case. That makes sure that you can get something out of it, and it's going to be their responsibility to then sue their employee for violation of their, employee handbook or whatever it is internally that they had to ensure that was going on. So that's a great question.
Yeah. How about when you see those women or those books come out about, people writing about the behind the scenes things that happen? Is that because the NDA expired and they were then able to write about it? Because it's condemning and slamming the business sometimes.
Well, those things were probably done after the release of their employment agreements, let's just say. So there's, again, similar language in an employment agreement about, non-solicitation or, non-disparagement is really what that's about, disparaging a company that they've worked for. And there's time periods of that. So they probably, waited till it expired and then we're able to have the conversations. If they had that, unfortunately, I've worked with really big brands that didn't even have exit contracts. So when an employee left, they never signed anything that confirmed that they're not going to do anything and they're not going to say anything. And it wasn't necessarily in their employment agreement either. So it left that room wide open for them to disparage the company after they left because they didn't stop them.
So you're saying they have the employee agreement at the beginning that they sign before they start work, but then if somebody is leaving your company, like before you give them your final paycheck, they need to sign an exit contract.
Yeah, a release, basically. Yes.
Okay.
Yes, a release agreement. So they release everyone, and they're, you agree not to sue them for anything, and so basically you're wiping away, you're walking away clean.
And they can't share any of your company plans with their next employer.
Exactly, and non-solicitation, so they can't go and get your clients or the people that you're working with. That's important. Non-compete, exactly. That's, depending on the industry, that can be applied. So there's different things that you need to make sure that you do with your employees, and before they finally exit when they're leaving, to ensure that they're going to continue their obligations that they have after they leave your employment. Or, even if you've been working with someone independent as in a contractor relationship, you just remind them, hey, you signed this agreement, you're still under this agreement. So.
Okay, Dale, did you have an additional question?
I did, and more of a comment, I guess, question and a comment. I find it very challenging to really protect ideas and brands, and even more challenging to monitor and track everything. And I mean, we have Google alerts on all the time, so hopefully you could find it if someone's stolen something, an idea or something from us, or started something competitive. But do you have any other advice for how you can monitor and track all this so you can identify it and nip it in the bud?
Well, if you really did make the investment into your brand, there are companies that have a watch service, and I've worked with them. So they'll give you a rate depending on the jurisdiction that you want, and they have worldwide jurisdiction coverage. So, you know, they can watch if it's done on, you know, all of the platforms, all websites, and even, you know, actual location. So there are services that you can get you know, a watch service that will keep an eye on your brand and make sure no one else is infringing it.
Mm-hmm.
Fantastic. If you have any names to recommend, let me and everyone know. I would love to check it out. And thanks so much.
Yeah, no, absolutely. I can, you know, as we're talking, I can actually pull up a few that I've worked with in the past.
Before we sign off, I'd like to make a suggestion that people start using a service like Adobe Sign, or I think Hello Sign's another one. There's several electronic signature companies and apps that you can use. And the reason why I like to do it is, I mean, number one, I think it gets the contract signed faster, because a huge number of people nowadays do not have printers. And if you ask me to print something off, it will be delayed until you ask me at least 3 times. So, but if you, and so the other reason I use the electronic signature is because I keep everything in my Adobe Sign account. So when I send out a contract, you know, it's just like one click for them to sign it. It's super easy. And then it's stored in my Adobe account. And then I never have to worry again about where my signed contracts are, because they're all in there forever, as long as I pay that monthly fee. But I'm sure you can download as well.
Yeah.
Yeah. So that's my suggestion. And then, Shirin, if you quickly have something, okay, yeah, you, Clarivate, you put that in the chat. Okay. Okay, well, thank you everybody for coming today. If you want to connect with anybody on the panel, sign into your Fashion Mingle dashboard and go to the Message Center, and you can send a message to any of us and ask any questions. Let's see, next Friday is going to be our monthly Mingle Mastermind networking event. And so that will be where everybody gets to come on, they get to introduce themselves, say what they're looking for. This is a great opportunity to share what you're doing, but also ask for resources and answers to any questions you have about any issues that are, you know, causing a problem with your business. And then remember, the second Friday of the month is our marketing series, and the third Friday of the month is our sustainability series. And then we'll be back on the fourth Friday of the month to talk again about the things that we didn't get to on today's list. So thanks everybody. Have a great weekend, and see you next week.
Thank you. Have a great weekend, girls.
Bye.
Thank you, Shirin.